question is that the bill be now read a second time. I must inform the House that I have selected the amendment in the name of the Leader of the Opposition. I remind the House that, of course, front bench speakers can speak without a time limit, and they have to be sensitive to the number of people who wish to intervene on them. So I merely note, and colleagues can make their own assessment, that on current progress, probably somewhat fewer than half of those who wish to speak today will be able to do so. Colleagues obviously need to help each other. Sir Keir Starmer.
Keen to portray this bill as a technical exercise converting EU law into our law without raising any serious constitutional issues about the role of Parliament. Nothing could be further from the truth. Mr. Speaker, let me start with Clause 9. The Article 50 negotiations that the Secretary of State and the Prime Minister know are among the most difficult and significant in recent history. Under Article 50, the agreement will cover all of the withdrawal arrangements and take account of future relationship between the UK and the EU. A backwards look and a forwards look, and something which may last for decades. We know from Phase 1 it will have to cover EU citizens, Northern Ireland, UK citizens in Europe, the money. Phase 2, of course, will cover security, cross-border crime, civil justice, enforcement of judgments, fisheries, farming, Gibraltar, you name it. We hope it will be in the Article 50 agreement. We want that to succeed. We need an agreement. And of course, it will include our future trading arrangements. Hugely important, including any transitional arrangements, if there are such arrangements, and much more. Arguably, the arrangements will, and these are not my words, but I'll come back to them, extend to every facet of national life. That Article 50 agreement will be voted on, but it will then have to be implemented. A colossal task likely to involve a whole host of policy choices and require very widespread changes to our law on any view. So how will that be done? Enter Clause 9. A Minister of the Crown may by regulations make such provision as the Minister considers appropriate for the purposes of implementing the withdrawal agreement if the Minister considers that such provision should be in force on or before exit day. Well, it's very likely to have to be enforced before exit day, because otherwise there will be a gap. So that means the whole of the agreement being implemented under Clause 9. The whole of the agreement, including transitional measures. It won't be implemented after exit day, otherwise there will be the gap. Let's be clear about how wide Clause 9 is. We've had some discussion about Henry VIII. Let's read subsection 2. Regulations under this provision on the withdrawal bill may make any provision that could be made by an Act of Parliament. It's a true Henry VIII. It can modify Acts of Parliament, in brackets, including modifying this Act. The delegated legislation can amend the primary Act itself. That is as wide as I've seen in my experience. What are the limits? You might think, what are the limits? What are the safeguards? Well, Clause 9.3, only these. You can't impose taxation, retrospective provisions, well, they're usually a very bad idea, create a criminal offence, or affect the Human Rights Act. Everything else is on limits under Clause 9. Everything else is on limits under Clause 9. Everything. I will just make this point, and then, of course, I'll give way. Surely then, for Clause 9, and I'm using this as an example, you would expect somewhere in here an enhanced procedure, safeguard, surely not just ordinary old delegated legislation. Surely something when it's as wide as this. I'm going to make this point, and I'll of course give way to a number of people when I've done it. What are the procedures? Are they enhanced? No. The opposite. Schedule 7, Part 2, deals with Clause 9. And it makes it clear that unless the delegated legislation creates a public authority or the functioning of a public authority, affects a criminal offence or a power to make legislation, it is to be dealt with by what? The negative procedure for statutory instruments, the least possible scrutiny. So the widest possible power, no safeguards, channelled in to the level of least scrutiny. That is absolutely extraordinary. And let's be clear what that means. Because I'm sure the Secretary of State and others will say, well, notwithstanding the number of statutory instruments under this provision, they could be called up and annulled. Parliament has its say. I looked up the last time a negative procedure statutory instrument was annulled in this House. 38 years ago. I don't know how many people have been in this House for 38 years, but many of us will have not had the opportunity. Oh. So much for taking back control. And there's no point the Secretary of State or the Prime Minister saying, well, we wouldn't use these powers, take our assurance. If you wouldn't use them, they're unnecessary. And if they're unnecessary, they shouldn't be put before this House for approval today. I will give way.
Thank the honourable gentleman for giving way. The case he's making is for an amendment to Clause 9. He is not making a case against the principle of this bill, which is what second reading is about. And yet he and his party are determined to vote against the principle of the bill. He ought to make that case.
I've only just started. I'll give way.
Thank you, Mr. Speaker. The Secretary of State made great play that this bill is necessary for certainty. But given the legal situation that my right honourable friend has just excellently elucidated, would he agree with me that the powers that this gives Secretary of State over regulating every aspect of our lives means that this bill is a charter for uncertainty for ordinary British people?
Yeah. I would, and I'm going to attempt to demonstrate that. I will press on. I know people want to intervene, but I hear what the Speaker says about the number of people who want to speak, and I will try to take them at intervals if that's satisfactory for the House. The same approach to Clause 9 is taken to Clause 7 for dealing with deficiencies arising from withdrawal, and under Clause 8 complying with international obligations. All of them channelled into the negative procedure with the least possible scrutiny. A giant sidestep of parliamentary scrutiny on the most important issues of our day. But let me top it off. If you think that's bad, and I do, try Clause 17. Try Clause 17. A Minister of Crown may by regulations make such provisions as the Minister considers appropriate in consequence of this Act. That's it. Anything in consequence of the Act can be done under Clause 17. Again, making it absolutely clear, this is a proper, robust Henry VIII. Look at subclause 2. The power to make regulations under subsection 1 may be exercised by modifying any provision made by or under any other enactment. That means amending Parliament. That means amending primary legislation. And this, subsection 3, in case anybody's in doubt, in subsection 2, enactment does not include primary legislation passed or made after the end of the session in which this Act is passed. So it can amend any legislation whatsoever, primary legislation, including legislation in this session. Everything in the Queen's speech that's coming down the track could be amended by delegated legislation under Clause 17. I've never come across such a wide power. I've seen consequential powers. The Secretary of State will no doubt point out other statutes that have not dissimilar powers. I've looked at them. I've never seen one as wide as this. Don't just take my word for it. Don't take my word for it. The Secretary of State a minute ago said nobody could suggest that this was a blank legislative cheque for the government. Nobody could. Let me read to you the Hansard Society. Not a political body, not the opposition, the Hansard Society. About Clause 17, and I quote, "Such an extensive power is hedged in by the fact that any provision must somehow relate to the withdrawal from the EU, but given that this will arguably extend to every facet of national life, if it was granted, it would in effect, their words, hand the government a legislative blank cheque." Hansard's words. I need to just complete this part of my presentation, if I may. A legislative blank cheque. So what's the scope and extent of this, Mr. Speaker? Mr. Speaker, how many pieces of delegated legislation are we concerned with here? The White Paper, as the Secretary of State has said, suggested 800 to 1,000, the vast majority of which will go in the negative procedure route. I don't think the White Paper could or did take into account the further instruments necessary to implement the withdrawal agreement, which could be very many more. Well over 1,000 pieces of delegated legislation with the least scrutiny possible. Now, I will complete this point and then I will give way. I was glad to see the Prime Minister was here earlier. Yesterday, during Prime Minister's questions, the Prime Minister told the House that, and I quote, "The government's approach to this bill has been endorsed by the House of Lords Constitution Committee." That's what she said yesterday at that dispatch box. I went and read again that report last night. I have doubts about that endorsement, but when I finish this point, but as she and the Secretary of State will know, this morning, the House of Lords produced its further report on the bill, published this morning. It concludes, I quote, "The executive powers conferred by this bill are unprecedented and extraordinary and raise fundamental constitutional issues about the separation of powers between Parliament and government," end quote. It goes on to say, it's the report that yesterday, or the committee that yesterday the Prime Minister was praying in out, "The number, range and overlapping nature of the broad delegated powers would fundamentally challenge the constitutional balance of powers between Parliament and government and would represent a significant and unacceptable transfer of legal competence," end quote. Far from an endorsement, it's an explicit and damning criticism of the government's approach. I will be quiet.
Can I absolutely agree with my right honourable friend for pointing out what a joke this bill is, setting out all these supposed safeguards, but correctly he points out that the ministers can make regulations to modify this act. So we're sort of disappearing down that Alice in Wonderland rabbit hole of legislation. And will he also agree that it doesn't matter when ministers opposite, Prime Minister, the Secretary of State, say, "Oh, trust us, we won't use these regulations," because they could be here today and gone tomorrow, and the honourable member for the 18th century from Somerset could be Prime Minister. We could be in his hands totally with all of these powers.
Trust me.
I'm grateful for that intervention.
Order! I think we can short-circuit this. The honourable gentleman for North East Somerset has often been noted to observe that the 18th century is altogether too recent for him. Sir Keir Starmer.
Wait twice, because I think there have been two interventions that have been...
Thanks. Could he go back to Clause 9? In relation to what is being called the divorce bill, the amount of money that we may have to pay to the European Union on exiting the European Union, is it his view that under Clause 9 that could be agreed
by a minister, by government, without this place having any say over the amount of money paid at all.
If it doesn't come under Clause 9, it would certainly come under Clause 17. I give way and I apologise for taking the wrong order. to hear.
Thank you very much for giving way. And as a new member, I also looked at advice on how Parliament has looked at statutory instruments, and I too saw that the last time that instruments were annulled by this House was back in 1979. The issue was actually on the cost of paraffin, and I remember 1979 and the high cost of fuel. It was a significant issue. But given that the Secretary of State has said in response to the intervention from the member from Broxtowe that he is prepared to consider a sifting process, which means that serious issues do come back to this House, what is your alternative? What are you proposing? Thank you. Sorry.
Being made for the first time today. These are the points being made since the White Paper was published. The moment we dealt with it, that was in March. The bill was published in July. There have been numerous reports since then, and I raised at the time the significant issues that I'm raising now, and there's been no move from the government. I will give way, and then I am going to move on.
I'm very grateful. But the key point about Section 9 is that it allows that the government has asked Parliament to allow it to alter the bill itself by secondary legislation once it's been enacted. If you look through the history of the 20th century, you will not find a single bill that has ever sought to do that. Not in time of war, not in time of civil emergency, and in fact, for every single Emergency Powers Act have expressly said there shall not be a power for ministers to alter the primary legislation.
Well, I'm grateful for that intervention. I'm on my feet answering the last intervention. It powerfully makes the point that this Act is unprecedented in its scope. It is significant because the Secretary of State will point to some of the safeguards under the Act for the exercise of some of these powers. But if the delegated legislation can amend the Act, then notions of exit day, how far the delegation legislation go, what procedures are used, could be amended by the delegated legislation. So it's a very real point. Mr. Speaker, I am going to press on. I am going to press on. Let me turn from parliamentary involvement to the protection of rights. Many rights and protections derived from the EU are protected in delegated legislation under the 1972 European Communities Act. Because they're underpinned by EU provisions, they've enjoyed enhanced protection, 44 years' worth. They include some very important rights. The working time rights of people at work, the rights of part-time and fixed-term workers, the transfer of undertakings provision, which affect everybody who's at work if their company is taken over, so that their contracts are preserved, something we all believe in. All health and safety provisions have been by delegated legislation under the 1972 Act. It didn't matter that it was just delegated legislation because they had enhanced protection because of the 72 Act and because of our membership of the EU. The same is equally true of important environmental rights and protections for consumers. Under this bill, the Secretary of State says they survive, and I accept that, and he does have a commitment to rights at work. But they don't survive with their enhanced status. They survive only in delegated form. From the date of this bill, they are amendable by delegated legislation. All of those rights at work, those environmental provisions, consumer rights, they are protected only, they're unprotected from delegated legislation. I will give way twice in that order.
On the specific point of health and safety protections, he knows, of course, that there is in fact a 1974 statute, the Health and Safety at Work, etc. Act, which gives not just employees safety protections, but also members of the public who are affected by conditions in the workplace. Surely that in itself acts as the primary protection to workers in this country under health and safety provisions.
No, I'm afraid it doesn't. The Manual Handling Regulations 1992, Management of Health and Safety at Work Regulations, Health and Safety Regulations 1992, all of which postdate that. And in any event, that doesn't deal with all the other rights that I said I would give way.
I'm grateful to him for giving way, and he's making an excellent speech. On the issue of environmental standards, would he agree with me that there's another problem, which is this governance gap? In other words, with the lack of the ECJ, the lack of the Commission, there is nothing to enforce those environmental standards, and therefore we need a new legal architecture. Judicial review is not enough.
I'm very grateful for that intervention, because one thing that is not on the face of the statute is any enforcement provision for rights which are currently enforced in one or other way through EU institutions or even reporting obligations. Now, it's fair to say that there is a provision in the Act for the creation of public authorities by, guess what, delegated legislation, and it may be that could be used for remedies, but it's by no means clear on the face of the bill, and I think that's an important deficiency. But let me just complete this point, because does it matter that these rights have lost their enhanced protection? Well, yes, it does. Taking back control obviously carries with it this Parliament can change those rights, as the Secretary of State rightly set out. But this is to change them by delegated legislation, not primary legislation. That is an important distinction. Does it matter? Would anybody have a go? Surely not in the 21st century. Well, Foreign Secretary, June 2014, calling for an end to back-breaking employment regulations, specifically Collective Redundancies Directive. The International Development Secretary, during the referendum campaign, calling for the government to halve the amount of protection given to British workers after Brexit. And the International Trade Secretary, I'm addressing the question whether it's conceivable that a Conservative government might change this. I'm reading out the statements of 3 cabinet members. International Trade Secretary, February 2012, to restore, and I know the Secretary of State heard the quote already this morning, to restore Britain's competitiveness, we must begin by deregulating the labour market. Political objections must be overridden. It's too difficult to hire and fire and too expensive to take on new employees. It's intellectually unsustainable to believe that workplace rights should remain untouchable, while output and employment are clearly cyclical. Now, this Secretary of State has a proud record on human rights and protections of people at work, but these are Cabinet colleagues, and this power in this bill allows these rights to be overridden by delegated legislation. I will give way.
Gentleman for giving way, but isn't there a fundamental contradiction in what he's been saying? A moment ago he was worrying that power would be lost from this House. Now he is saying the power should in fact be with the European Union. Isn't this the fundamental point of this bill? That it is better that laws should be made by our government and our Parliament than by an unelected EU bureaucracy.
Mr. Speaker, I'm obviously a very bad communicator. I thought I was suggesting that workplace rights, environmental rights, consumer rights should only be capable of being taken away by primary legislation. If there's any doubt, I can assure the honourable member, I meant when I say primary legislation, I mean legislation in this House. I thought that was taken as read. I give way.
Shadow Secretary of State for giving way. But doesn't the last intervention point to the fundamental misunderstanding that some people have about this bill? And actually, I'm afraid the Secretary of State mentioned it in his intervention. The point is whether the UK is going to become a rule taker rather than a rule maker. Our membership of the European Union has allowed us to influence the directives and regulations which have then been taken on board in this House and through our laws. What we are doing in this bill, and I will expand this remarks, is saying they're not repealing,
we are reintroducing European legislation into this country, contrary to those who wanted to leave the European Union.
And take back control.
I'm grateful for that intervention and agree with it. Mr. Speaker, can I move on to other rights? Because they're dealt with more severely. Clause 5.4 singles out the Charter of Fundamental Rights for extinction. There are thousands of provisions that are being converted into our law and will have to be modified in some cases to arrive in our law. Only one provision in the thousands and thousands has been singled out for extinction: the Charter of Fundamental Rights. As the Right Honourable Member for Beaconsfield argued in an article published yesterday, the principles of the Charter provide essential safeguard for individuals and businesses, and that has been particularly important in the field of LGBT rights, children's rights and the rights of the elderly. Does it matter, says the Secretary of State, does it matter? Tell me why it matters. I've got here the High Court judgment in the case of David Davis MP, Tom Watson MP and others versus the Secretary of State for the Home Department. It's 2015. The then Home Secretary was the now Prime Minister. David Davis, the backbencher, suing or bringing to court the now Prime Minister. He was challenging, he will recall, the provisions of the Data Retention Investigatory Powers Act 2014. And he was very concerned that it would impinge on the ability of MPs to have confidential communications from their constituents, a point he continued into the debate that we were having a year or two ago. In his argument, he cited the Charter. His lawyers said the Charter was important. His lawyers made the argument that the Charter was important because it went further than the European Convention of Human Rights and therefore was an added protection. I won't read out paragraph 80 of the judgment, which I'm sure the Secretary of State is familiar with. But as he knows, the court found in his favour that that was right. The Charter did enhance his right. And for that reason, it rejected the arguments of Mr Eadie, a distinguished QC. He was the then Home Secretary, now Prime Minister's QC. So I'm going to complete this point. So when he says, will it make any difference? Yes, here's his case. I suspect, if the Secretary of State was still on the benches further behind him, he would be talking to me over a cup of coffee and others about how we fiercely ensured that Clause 5.4 of this bill came out. Let me now. Mr. Speaker, I'm going to make progress because I do know lots of people want to come in. I'm going to make progress. I give way.
I'm most grateful to the Right Honourable Gentleman as he makes a very important point. I think, reading the mind of my Right Honourable friend, why he said does it matter was because he would insist that the general principles of EU law being preserved would replace it. But of course, if they're not justiciable because you don't found a cause of action in our courts, then the ability to assert these rights will, of course, evaporate.
Exactly the point that my Right Honourable member made earlier on. To say you can find the right elsewhere so it doesn't matter, and then you remove the right to actually do anything about by an effective remedy, means that you've achieved absolutely nothing through the exercise. I will give way.
Paul. Will the honourable gentleman be good enough to explain why it is that other distinguished gentlemen, namely Tony Blair and Lord Goldsmith, fought so resolutely to exclude the Charter of Fundamental Rights from the Lisbon Treaty and furthermore failed because their protocol did not actually work?
No. I spent 20-plus years as a human rights lawyer interpreting and applying provisions such as the Charter, enacted for many people where it made a real difference to their lives, as the Secretary of State will know. Let me move on, Mr Speaker, to devolved powers. At the moment, EU law limits the powers of the devolved administrations. Upon withdrawal, the default position ought to be that the devolved institutions would have power over things falling within their devolved fields. But Clause 11 prevents that and diverts powers which ought to go to Edinburgh, Cardiff or Belfast to London, where they're to be hoarded. Fundamentally the wrong approach, but totally consistent with the government approach of grabbing power and avoiding scrutiny. On that topic, let me deal with Exit Day, a crucially important day under the bill. It's the day upon which the European Communities Act is repealed. It's the day upon which the role of the European Court of Justice is extinguished in our law. That matters hugely. Whatever your long-term view, that matters hugely, particularly for transitional matters. I heard the Secretary of State this morning say that he did want an arrangement for transitionals which was as close as possible to the current arrangement. I think he knows in his heart of heart that will almost certainly involve a role for the European Court of Justice. He would say temporarily. He knows that. So the exit day, the date on which the role of the court is extinguished, is crucially important. Without it, you can't transition on the terms that the Secretary of State was suggesting this morning, or you might not be able to, and he knows it. Control over exit day is therefore hugely important, Mr. Speaker. Control over exit day. Who has control? Bring back control. You might think Parliament on this very important issue. But no, enter clause 14. Exit day, 30. Exit day means such day as the Minister of Crown may by regulations appoint in the sole power of the Minister. Anybody simply passing this bill is prepared to be a spectator on the question of what the transitional measures should be and how they operate. That is a huge risk to our national interest. I will give way.
I'm grateful to my honourable friend for giving way. The Secretary of State said it was silly for me to raise this issue early in relation to the transitional arrangements insofar as they may relate to us continuing to be in the single market and the customs union. If this bill is enacted and we're outside of the purview of the ECJ and we are not subject to EU law, then we are effectively ruling out single market and customs union for the transition. How does that give stability and certainty to British businesses? And why is this provision in the bill?
This is the conundrum the Secretary of State and this bill has got into. If exit day is March 2019, then it's very difficult to see how you transition on terms similar to those that we're on. What do? You could push exit day, because it can be chosen, 2 years down the line. Well, if you don't do that, but you want and recognise that the ECJ is necessary, you end up repealing what was once the repeal bill to put it back in again. That is the extent of the absurd powers in this bill. I will give way.
I'm very grateful to the Right Honourable Learned Gentleman for giving way. He's making an outstandingly concise and forensic speech dissecting the difficulties in this bill. And he's drawn attention to the problem with the definition of exit day. Does that problem also feed into the delegated legislative powers? Because clause 7.7 says that the ministers can make regulations under this section after the end of period of two years beginning with exit day. Now, if exit day is going to disappear down the line, as he has indicated, does that not indicate that the power to make delegated legislation is going to continue for even longer than the government say?
It certainly could. It certainly could. The only way out of that is to have multiple exit days. Now, you might think I'm joking, but somebody who drafted this bill thought of that, because that's conceivable. Multiple exit days, all chosen by a minister, not by Parliament. Mr. Speaker, let me draw to a conclusion. The combined effect of the provisions of this bill would reduce MPs to spectators as power pours into the hands of ministers and the executive. It's an unprecedented power grab. Rule by decree is not a misdescription. It's an affront to Parliament and to accountability. The name of this bill was changed from the Great Repeal Bill to the EU withdrawal bill. The word great should have been preserved, but it should have been changed to the Great Power Grab Bill. Labour voted for the Article 50 Act. That's because we accept the referendum result. As a result, the UK is leaving the EU. That we are leaving is settled. How we leave is not. This bill invites us to surrender all power and influence over that question to the government and to ministers. That will betray everything that we were sent here to do. Unless the government makes some very significant concessions before we vote on Monday, Labour will table and has tabled its reasoned amendment and vote against the bill. Thank you, Mr. Speaker.